12 October, the Court of Appeal in Botswana heard the case of LM versus Attorney General. The case was about the criminalisation of consensual sex between people of the same sex in Botswana. It's a case that affects many people throughout Botswana, and the court was filled with members of the LGBTQIA+ community, which was unbelievably encouraging because within the region it is very hard often for people to attend the court in cases that affects their lives, and in this instance they were able to do so, to hear the arguments and to support the parties that were involved in the litigation. What was quite interesting, so it was before a Court of Appeal bench of 5 judges, a Court of Appeal of 5 judges, the Judge President, Justice Kirby, the Chief Justice, Justice Ranawane. There were also Justice Galegwe, Justice Lesetedi, and Justice Mercy Garekwe. And the judges were unbelievably engaging. This is a bench that thrives on good jurisprudence. It's a bench that really did their homework before they came to court. They read the arguments, they interrogated the lawyers. So what we're hoping is that we can get a judgment that will be well considered and that would actually show other courts throughout Africa how to deal with LGBTIQ issues in a way that respects rights, in a way that is thoughtful and follows normal jurisprudential reasoning, and that doesn't get sidetracked by issues such as religion and public opinion and those sort of things.
So we are just about to leave Gaborone after attending the court case, the appeal, and it was a very interesting experience, right? I was incredibly impressed at how the judges interrogated some issues. One of the things that I thought was interesting that the judges brought up was what does it mean to be vulnerable? When are you vulnerable? And they even talked about minority issues, and I think a really good point that came up, which is unfortunately one of the weaknesses of any democracy, is how do minorities access parliament? How do you gain access to parliament to advocate for your issues, but also at what point are your numbers enough or your issues important enough to actually sway parliament? I thought that was an interesting point.
The applicants and Lekhabebo won in the High Court, and in the High Court we received a wonderful judgment from a 3-panel bench, and the bench basically said that laws which criminalize consensual sex between same-sex couples are unconstitutional because they violate the right to dignity, the right to liberty, the right to equal protection of the law, the right to privacy, and the right not to be discriminated against. What is quite unique about the High Court judgment is that it interpreted the non-discrimination clause very progressively. So in all countries, there's a constitutional provision which says that you cannot discriminate against people on the basis of sex, race, and a number of other grounds. And the Botswana High Court interpreted the word sex to include sexual orientation because they said that's a fundamental part of sex. And that was a broad reading, it was a correct reading of the definition of sex, and it meant that you cannot discriminate against people on the basis of sexual orientation. The Attorney General decided to appeal that decision. They appealed it on a number of grounds, but they also appealed it because of the reading of sex as including sexual orientation. And the Attorney General then found an interesting new argument. They said that Section 59 of the Constitution, which is the non-discrimination section, specifically says that the non-discrimination provision in the Constitution doesn't apply to laws predating the Constitution. So it doesn't then apply to the Penal Code, which is 2 years older than the Constitution. Now, this argument is a very problematic one because it dates back to all independence constitutions that were drafted by Britain, it was specifically inserted to ensure that, in a sense, the status quo and the privilege that the colonialists had within those countries are somehow maintained. So their interests are still maintained even once a country becomes independent. In a sense, it's ludicrous provisions, because it cannot be that a law created in a colonial era can somehow be more valid than and less open to scrutiny in terms of the constitution than laws created thereafter. So this was a key question that was before the court. It's a question that has also come up in other LGBTQI decisions throughout similar countries where there were those sort of independence constitutions with the so-called savings clauses. And the Caribbean Court of Justice had recently actually given a quite progressive judgment specifically on the issue of savings clauses, where they said that we have to remember that these were transitional provisions that were enacted to ensure that the rule of law doesn't fall apart as you enter into a new democracy. But they did not intend to keep alive laws which discriminate against people. And that is really the right reading of that provision. So that's the one argument by the Attorney General in their appeal. The other argument by the Attorney General is that the High Court didn't respect separation of powers, in that this is whether or not to criminalize gay sex is a policy decision according to the Attorney General, and it is something that only Parliament can decide on and not the courts. That argument we submit is wrong, because the Constitution itself allows anyone whose rights have been violated to approach the court. So if they can only approach the court in matters that doesn't require parliamentary legislative reform, then many rights will be violated while people sit around and wait for the courts, wait for Parliament to make their decision.
I'll be very disappointed and also somewhat surprised if we lose this, because I genuinely feel the law is on our side. I also felt that some of the AG's arguments were a little bit scary, comparing us as queer people to drug users and other, talking about at some point even very briefly about bestiality. I thought those were a stretch too far, but I still think it was a good court case, and I'm very glad that this is actually being dealt with by what I thought was a very responsible bench. From across the bench, judges asked really good questions, which to me says they're really engaging with the issue.
So the case was about challenging three sections in the Botswana Penal Code. The one is section 164, subsection A and subsection C of the Penal Code. These are the colonial sodomy offences. So it makes it a crime, it says, to have unlawful carnal knowledge of someone else and to permit someone to have unlawful carnal knowledge of you. And unlawful carnal knowledge is historically interpreted by the courts to mean anal penetration. So in Botswana, these offences are gender neutral. They weren't always like that. So in theory, they could also apply to heterosexual couples who have anal penetration or anal sex, but in practice they do not. And in practice, these offences stigmatize specifically the LGBTQIA+ community. The other offence that was challenged was section 165, which is basically the attempt to have unlawful carnal knowledge. And then the final offence was section 167 of the Penal Code. Section 167 of the Botswana Penal Code criminalizes gross indecency. It's a gender neutral offence, so it's an offence that basically makes sexual acts between people, same-sex couples, unlawful, and it includes lesbian couples and gay couples. The offence also doesn't really distinguish between private acts and public acts. So what the High Court had said in the same case was that the offence is constitutional to the extent that it criminalizes public acts, but it's not constitutional to the extent that it enters into people's bedrooms and criminalizes what they do consensually in their bedrooms. So the case was brought by one LGBT QIA individual, a gay man from Botswana, who wanted to challenge the legal provisions on the basis that they limit his rights and limit his ability to express himself. The case was joined by Lesbians and Gays and Bisexuals of Botswana, which is an organization that fights for the rights of LGBTQIA persons. And their case was then supported by the Southern Africa Litigation Centre. And what Lekhabibo sought to do was actually to broaden the arguments before the court to show that these offences have not just a passing but a direct impact on the lives of LGBTQIA persons on a daily basis. So the evidence we brought to the court showed how having laws that criminalize people's sexual behavior leads to stigma, it leads to discrimination, it impacts on their ability to express themselves, it leads to a deterioration in mental health, often increased rates of suicide and depression, the inability to access healthcare services, and just a general denial of their humanity, where people feel degraded, they feel humiliated, they're basically not treated with dignity, they're treated as another person. So everything they do is seen within the lens of a penal code that criminalizes one specific act of their lives. So it was a very important case. At the same time, there are huge debates throughout Africa and throughout the world. In a similar court case in India, the same offence has been declared unconstitutional. The same has happened in Belize, in Fiji, in a number of other countries. Trinidad, which are the other countries? Great many other countries. But so sometimes these offences are challenged in the courts, and sometimes they are reformed through Parliament. And although we would ideally like Parliament to be on top of things, to comply with international law and to reform laws so they respect the rights of everyone, sometimes this takes long. Sometimes Parliament is consumed with other things. And that's when, if anyone feels their rights are violated, they can go to the court and assert those rights. And that's what happened in this case. It's not that the Botswana government had been hostile towards LGBTQI persons, but they had not gotten around to reforming their penal codes. And the penal code dates back to 1964, so it's old. It's a colonial era law that came into effect before the Constitution of 1966. And it's such a large law that I think the law reform process itself is sometimes overwhelming. So if there are individual sections in those penal codes that require challenging because they infringe on violation of rights, it's within everyone's right to go to court and to challenge those. The case that was heard in the Court of Appeal comes 18 years after a similar case was heard in 2003 in Botswana that is known as the Kanane case. And in that case, the court had declared the exact same provisions constitutional. But the court had left open a window, the Court of Appeal, to say that at the time it didn't have enough evidence of violation of rights to declare the provisions unconstitutional, but it doesn't mean that in the future it might not do so. So the reason why the case was brought now was because many people were of the opinion that 18 years later the position has indeed changed, and that there has been a number of indications within Botswana that attitudes towards LGBTQI individuals had changed. So that this was a key issue that was before the court about had there indeed been that change, and had the High Court been right and allowed to overturn the Kanane decision based on that change. So the amicus had put forward evidence of a number of indicators of that change. For example, the Employment Act was amended in 2010 to say that you cannot discriminate against employees on the basis of sexual orientation. The previous Court of Appeal judgments had allowed LGBTQI organizations to register and had made positive statements about the diversity within Botswana, about changing attitudes and about the rights of LGBTQI individuals being the same as the rights of all other individuals. There had also been some significant government documents about the way in which these laws impact on access to healthcare services for the LGBTQ community, and how they actually hamper broader initiatives by the government of Botswana to improve the health and well-being of its citizens.